Hello and welcome to the Minimum Competence episode for Monday, July 8th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have Boeing pleading guilty to fraud in the 737 MAX crashes, a Republican challenge to ESG investing rules, Tesla shareholders contesting a $7 billion legal fee, and updates on Senator Menendez's corruption trial. Let's remember, the best way to cheer yourself up is to try to cheer somebody else up and read today's legal news. On this day in legal history, July 8th, 1777, Vermont made history by becoming the first state to abolish slavery through the formal adoption of its new state constitution. This landmark event occurred during the American Revolutionary War, reflecting the evolving values of liberty and human rights among the colonists. Vermont's constitution, drafted in Windsor, boldly declared that all men are born equally free and independent, explicitly prohibiting slavery. This was a pioneering move, as the nation itself was still grappling with the institution of slavery, which would not be federally abolished until the 13th Amendment in 1865. The framers of Vermont's constitution were influenced by Enlightenment ideals and a commitment to individual freedom. Their decision set a precedent and provided a moral compass for other states and the future United States. Vermont's abolition of slavery marked an early and significant step toward the broader movement for abolition and civil rights in America. This moment in legal history underscores the state's progressive stance and its contribution to the fight for human dignity and equality. Boeing has agreed to plead guilty to criminal fraud conspiracy and pay a $243.6 million fine to settle a U.S. Justice Department investigation into two fatal 737 MAX crashes in Indonesia and Ethiopia that killed 346 people. This plea deal, pending judicial approval, marks Boeing as a convicted felon. The settlement has faced criticism from victims' families who demand a trial and stricter penalties. The guilty plea endangers Boeing's eligibility for government contracts, but spares the company from a potentially damaging trial. The agreement also mandates Boeing to invest $455 million over 3 years to enhance safety and compliance, and imposes an independent monitor to oversee these efforts. Additionally, Boeing's board will meet with the victims' families. The DOJ's charges stem from Boeing's false statements to the FAA about the MCAS software linked to the crashes. The deal does not protect Boeing from future investigations or shield its executives, and the court will finalize the plea agreement by July 19th. Boeing's criminal fraud conspiracy charge revolves around their false representations to the FAA regarding the aforementioned MCAS software, designed to push the airplane's nose down under specific conditions. This misrepresentation significantly contributed to the crashes, highlighting a grave breach of regulatory trust and aircraft safety protocols. A lawsuit challenging a Biden administration rule that permits socially conscious investing by employee retirement plans will be a significant test for how courts review federal regulations after a recent Supreme Court decision. The New Orleans-based 5th U.S. Circuit Court of Appeals will hear a case brought by 25 Republican-led states against the U.S. Department of Labor's 2022 rule, which allows 401k and other plans to use environmental, social, and corporate governance, or ESG, factors as tiebreakers in investment decisions. U.S. District Judge Matthew Kaczmarek initially upheld the rule based on the Chevron deference doctrine, which the Supreme Court has recently overturned, now requiring courts to independently address agency rules. This change is expected to impact various government regulations. The core issue here is whether the 1974 Employee Retirement Income Security Act, or ERISA, permits considering non-financial factors in investment decisions. Critics argue that such factors threaten workers' retirement savings. The Fifth Circuit, known for its conservative stance, may nullify the rule even without Chevron deference. The outcome will set a precedent for future challenges to federal agency powers and regulations. The case highlights the ongoing debate over the scope of federal agency authority and the influence of judicial interpretation on regulatory policies. Tesla shareholders will appear in court to contest a record-breaking $7 billion legal fee request linked to CEO Elon Musk's $56 billion pay package. This fee, sought by investor Richard Tarnetta for his legal team after winning a lawsuit that voided Musk's 2018 stock option pay package, has been called outlandish by many Tesla shareholders. Tarnetta's attorneys argue that they are entitled to 11% of the value returned to Tesla, approximately 266 million shares worth about $67 billion, asserting that this percentage is modest by Delaware legal standards. They seek payment in Tesla shares, equating to $370,000 per hour worked. Tesla and its shareholders argue that this fee is disproportionate and unprecedented, vastly exceeding the current highest shareholder litigation fee of $688 million from an Enron class action. Tesla contends that the fee should be as low as $13.6 million with an M, especially since shareholders recently ratified Musk's pay package, nullifying the supposed benefit of Tarnetta's legal victory. The case will be heard by Chancellor Kathleen McCormick, with a decision expected to take weeks or months. This ruling could set a significant precedent for future shareholder litigation fees. Closing arguments in the corruption trial of Senator Bob Menendez from New Jersey are set to begin after more than 7 weeks of testimony. Federal prosecutors allege that Menendez accepted bribes, including cash, gold bars, and payments for mortgages and cars, in exchange for aiding Egypt in securing U.S. military assistance and helping New Jersey businessmen with their legal and business interests. Evidence presented included gold bars and $480,000 in cash found at Menendez's home. Menendez, who has pleaded not guilty to 16 charges including bribery and fraud, is accused of using his wife, Nadine Menendez, as an intermediary for the bribes. Nadine Menendez, also pleading not guilty, will face a separate trial in August. The case has significantly impacted Menendez's political career, leading to his resignation as chair of the Senate Foreign Relations Committee. Despite running for re-election as an independent, his chances are slim. Key testimonies included statements from two New Jersey prosecutors and insurance broker Jose Uribe, who claimed to have bribed Menendez. Uribe testified that Menendez acknowledged helping him avoid state probes. Menendez's defense argued the cash and gold found were related to his wife's activities and their cultural background, citing Menendez's Cuban heritage as a reason for keeping cash at home. Menendez declined to testify. Closing arguments from prosecution will start in the early afternoon today and are expected to continue into Tuesday, followed by the defense's closing arguments. And with that, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, you can leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter form. We'll see you back here tomorrow, and until then, remember, money spent on air conditioning is money well spent.